All right. Hello, everybody. Got a quick start for you here.
Stetson, I guess what I'm concerned about, you talked in response to Justice Kavanaugh about what PLACA was about, what it was getting at, and I really thought, as the statute itself says, that it partially, at least, is about Congress protecting its own prerogative to be the one to regulate this industry. That there were concerns, and the statute itself says that, we're worried that tort suits are an attempt to use the judicial branch to circumvent the legislative branch of government. And to me, when you think about that as being the reason why Congress wanted to have immunity in this area, and I'm starting.
Okay. That makes a lot of sense, which is kind of surprising coming from her.
Not very often I agree with.
Right. With
Supreme Court
Jackson.
Justice.
Yeah. So today we're going to dive into this case. Basically, the Mexican government, just to make sure I understand, or Smith Wesson is the filer, but it's some kind of, it's basically Mexico trying to sue gun manufacturers.
Yeah. They're trying to see if they have standing.
Yeah. They're going to try to get to sue gun manufacturers
for gun violence,
for cartel violence. Cause absolutely. If, for example, you were an evil person and drove your Chevy van into a crowd full of people, obviously Chevy is the responsible party. Come on, man. Yeah. That's so dumb. It is so abjectly dumb. But we're going to get into it. It actually starts with Chief Justice Roberts. And I will do the best I can with getting the names on the screen. They do not give us it, so we have to do it ourselves. So I hope you guys will bear with me, but here we go. Wait, before we jump in, is there anything that you want to say about this before we kind of dive into it?
Not really, no. Just that
it speaks for itself.
It speaks for itself. I don't think that the Supreme Court's going to allow, as you will hear it, I don't think the Supreme Court's going to rule in Mexico's favor.
Okay. So even with these crazy liberals and, the swing votes, as they call them, right? Roberts and Amy Coney Barrett. Anyway, even with them, it does look like, at least based on the arguments we're hearing,
I think it's going to be 9-0.
Yeah, that's a hell of a claim. We'll see. Let's get into it. All right. Starts with
this morning. We'll hear argument this morning in case 23-1141, Smith Wesson Brands versus Estados Unidos Mexicanos. Mr. Francisco.
Okay. So we go right into Noel J. Francisco. And this person is the attorney for Smith Wesson Brands, S&W Brands. So they're apparently the plaintiff in this case, which I don't quite understand how that is. Do you know why Smith Wesson is the petitioner and why Mexico's the respondent?
I'm not exactly sure.
Okay.
I can try to figure it out.
Yeah, we'll learn more as we go, but let's get into this. Once again, we have Noel J. Francisco, who's the attorney for Smith Wesson Brands.
Mr. Chief Justice, and may it please the court. Mexico asserts that American firearms companies are responsible for cartel violence ravaging Mexico. Its theory is that federally licensed manufacturers sell firearms to licensed distributors, who sell to licensed retailers, a small percentage of whom sell to straw purchasers, some of whom transfer to smugglers, who then smuggle them into Mexico, hand them over to cartels, who in turn use them to commit murder and mayhem, all of which requires the government of Mexico to spend money. Needless to say, no case in American history supports that theory, and it's squarely foreclosed by the Protection of Lawful Commerce in Arms Act. As to proximate cause, this court has repeatedly said there must be a direct relationship between the defendant's conduct and the plaintiff's injury. But no such relationship exists if plaintiff's injury is caused by multiple intervening independent crimes committed by foreign criminals on foreign soil to inflict harm on a foreign sovereign. As to aiding and abetting, Mexico doesn't identify a specific crime, criminal, or criminal enterprise that defendants supposedly helped. Instead, it asserts that defendants are liable for every illegal sale by every retailer in America.
And that is just the most bizarre claim ever. Like, I can't even see the liberal justices going along with that. Now that you mention it, he's making a strong case for tossing this.
That's why I think it's going to be 9-0.
Interesting.
Because they know that a small percentage of firearms are sold illegally and don't do more to stop it.
Yeah.
Again, no case in history supports that theory. Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash.
Right.
The First Circuit gravely erred in embracing that implausible theory and should be reversed. I welcome your questions.
Okay. I think that's a great comparison. That's even better than the car one I came up with, because let's face it, there's a whole lot of steps between the gun manufacturer in the United States and it falling into the hands of cartel members. A lot of steps, and nothing that these gun manufacturers do, in my opinion, directly delivers this stuff to the cartels. Like, that's not what they do. If that was the case, then maybe you might have some kind of ground to talk about like causality, right? And legal ramifications
that's not
thereof.
the case.
But that's not what's happening. He laid it out. All right. We're going to go right into
Thomas, right?
Yes. Justice Clarence Thomas, who we're going to go 214 to 511. So a couple minutes. Here we go.
Mr. Francisco, as to the predicate exception, which federal or state law is petitioner reputed to have violated?
So my understanding, Your Honor, is that they're invoking the federal aiding and abetting statute to argue that we have aided and abetted the federal statutes that govern the sale of firearms. And they're alleging that retailers have knowingly sold firearms to straw purchasers and that we aided and abetting that knowing sale. That actually raises a very important question about their allegation of knowing. I don't think it's relevant because I'm willing to even assume a certain level of knowledge. I don't think it matters. But their theory of knowledge is that we actually know that retailers are selling illegally. I'd actually urge you to look at that 2010 Washington Post article that they incorporate into their complaint. That article talks about a particular retailer called Lone Wolf. In 2010, it was the #1 seller of firearms that were found in Mexican crime gun scenes. And in that article, you actually have a quote from ATF that says that ATF has no basis to believe that Lone Wolf is doing anything illegal or wrong. Well, if the government doesn't know, how are we supposed to know? It reflects this convoluted theory that simply because the gun is found in Mexico can be traced back to a retailer. That means the retailer necessarily sold it illegally, and that we know that the retailer sold it illegally.
Would this be?
That is a phenomenal point. If the government itself, our government, looked at this Lone Wolf, he called it, that's the name, I guess, of a retailer that was the #1 source for guns from in Mexico.
I never heard of it.
I hadn't either. I wonder if it has to do with Fast and Furious.
That's what I was wondering.
If you don't know what that is, look into it. We don't have time for that one too. But it is a good point that he makes, that even if the government itself was unable to find any wrongdoing or unable to point the finger at Lone Wolf, then how are we supposed to know if this, like, if there, I guess, is criminal activity, or how are we supposed to, like, determine fault if even the government couldn't find it?
And Fast and Furious, just going back for just a minute.
Yeah.
It was a scandal in the Obama administration where they were selling guns to cartels.
Mm-hmm.
Just, it's not a movie. It was actually a scandal.
Yeah. Yeah. We're not talking about the family. We're talking about Fast and Furious.
And I've seen the first one.
Eric Holder, right?
Yep.
Was the attorney general.
Yep.
And
he was impeached, or I think he was.
He was at least censured. I don't know.
Yeah.
There were some issues with him, but
anyway, let's go back to that.
Yeah.
Sold it illegally, and that we know that the retailer sold it illegally.
Would this be a different case if there was a specific federal or state statute that you were known to have violated?
Your Honor, it would be a different case. I would want to know more, because I still think that depending on what they alleged, I would have very strong arguments on proximate cause and aiding and abetting liability, but it would certainly be a different case.
Well, the reason I ask is because the exception is for knowingly violating a state or federal statute, and it would seem helpful in determining aiding and abetting, and then eventually proximate cause if that comes up, if you knew which statute we were dealing with.
So the complaint is a little bit vague on this. To the extent I understand it, they're looking at federal statutes that restrict the knowing sale of firearms to people who aren't authorized to purchase them. And then they're invoking the criminal federal aiding and abetting statute to claim that we're then liable for those illegal sales. I'm willing to assume, for the sake of argument, that that's valid, because I don't think they come anywhere close to establishing aiding and abetting liability. And even if they did, I don't think they come anywhere close to establishing proximate cause.
I'm sorry, counsel, but
Okay. We're gonna carry right on.
I think it's John.
Are
Roberts.
we just watching the whole thing? No, I see some skips. Okay.
Oh, yeah.
I was wondering, I'm looking and these are lining up. I'm like, wait a minute. No.
There's times.
Yeah. No, you're fine. I was just checking. All right, guys. So we're gonna go from here back to Roberts. There we go. All right.
To establishing proximate cause.
And this is going,
I'm sorry, counsel.
5:12 to 6:27. So a little over a minute for Chief Justice Roberts.
So, but exactly what role, I had difficulty telling from your brief, does foreseeability play in your proximate cause analysis?
So as this court has made clear in a number of cases, it's not that foreseeability is irrelevant. It's that foreseeability alone is not the standard. So it's necessary but not sufficient. In addition, there has to be a direct relationship between the defendant's conduct and the plaintiff's injury. And Your Honor, I think that the plurality opinion you authored in the Hemi group is directly on point. That is where a case where the plurality held that the city of New York couldn't sue a cigarette retailer for not filing the tax reports in order for the city to recover its lost tax revenue, because in between the city's injury of lost tax revenue and the retailer's failure to file the reports stood the citizens of New York who illegally failed to pay their taxes. And that broke the chain. This is a much easier case. Here we don't have just one intervening independent crime. We have a multitude of intervening independent crimes. So even if they could establish aiding and abetting liability, and I don't think they come even close under Twitter, they couldn't establish proximate cause, which is the other requirement here.
Okay. So there are some really good points made, in my opinion, in his argument, which is, even if we were somehow aware, even if you determine that, yeah, okay, we could foresee and prevent the sale, it doesn't rise to the level of aiding and abetting like they're claiming. I mean, that's kind of an insane leap, in my opinion, to go all the way to aiding and abetting when, I don't know, it's a little silly. But you know what? we expect this. We expect this kind of stuff. And we're going to come to them soon enough. But there's some interesting stuff I'd like to share with you about the other side of this, the attorney, and more importantly, where they work. Yeah, we were looking at it earlier. Okay, but we're going to move on to Sotomayor. And we're going to go about 3 minutes-ish with her. 6:28 to 9:46. Here we go.
Counselor, it seems to me that the cases are a mess on proximate cause. And you're asking us in this case to choose among a variety of different explanations of it. I think, however, I try to break this down. I think their complaint is saying that the violation is selling to straw purchasers. And I think the risk in selling to a straw purchaser, and that's the known risk of that violation, is that that straw purchaser is giving or selling the gun to someone who can't possess it because the likelihood is that they're going to use that gun illegally.
Now, one thing that I do want to point out, guys, based on, I guess, your interpretation, or I should say your firsthand knowledge of buying a firearm. Have you ever purchased a firearm? Okay. When you go in to buy a firearm from a licensed dealer, there's already background checks, ID. You got to fill out this form under penalty of perjury. That's when Hunter Biden lied on. There's already a process in place to catch the bad people. Now, what we're talking about straw purchases is Shawn goes into a gun store and he buys a firearm, and then he takes it outside and he sells it to Billy. Now, Billy has a criminal record. He couldn't buy a firearm. But because Shawn sells it to him, and more importantly, because that was his intention when he bought it, was to turn around and give/sell it to a prohibited person, then yeah, he'd be charged with a crime. Straw purchase is illegal. But Indiana, at least, has a little bit of flexibility there for family members, etc. And if you didn't plan on getting rid of it, you bought it, but then you changed your mind and decided to get rid of it, that's a different story in Indiana. But anyway, exactly how sure should gun manufacturers be that the person buying the firearm is the one that's going to use the firearm? How are you supposed to tell that?
Yeah.
I have heard stories from people who work in gun stores. There are those that are blatantly obvious about it. They'll come in, right? It'll be a dude, usually a dude and a chick that is going to be buying him something. He can't buy anything, but she's going to. And they're so dumb that they go in there and she's like, that one? And he's like, yeah. Make sure you get, whatever.
Wow.
Like, yeah. Like, I've heard stories from people who work in gun stores. Those, yes, obviously you turn them down, you send them away, whatever. But if somebody just comes in and purchases a firearm or several,
yeah, how are you supposed
to know?
Read people's
yeah.
mind.
Yeah. And it would look, we already have so many laws on the books, thousands,
and regulations.
And laws, regulations, all that, right? These tax stamps and all that crap. There's already a whole bunch of red tape and BS. These people are never going to be happy. When I say these people, the people who initiate this kind of garbage are never going to be happy until you lose your right to defend yourself and they can control you the way they control them in Mexico. How's that working out for them? The only people who are armed are the cartels. That's it.
And that's the risk of the violation. And I think that that's what their complaint says, which is, now, I'm going to put aside the lack of the conclusory allegations. And I agree with your point that they don't really tell us which dealers are doing this, who they're aiding and abetting. There may be a lot of conclusory allegations, but the theory, I think, that they're advocating is if you're selling to a straw purchaser, that's, you know, that the risk is that they're giving it or selling it to people who are going to commit crimes.
But again, how the hell do you know if this person is a legitimate purchaser or a straw purchaser? There's a limited number of ways you can like find out, and you're already required to collect all this information from people and go through this background check and do this and do that. Like, how many more hoops do both retailers and law-abiding citizens have to jump through in order to please you people?
Here, the Mexican cartel. So I don't know people who are going to commit crimes. Here, the Mexican cartel. So I don't know if this is a proximate cause case or it really is what you say it's not, or that the allegations are insufficient for aiding and abetting. I think for us to go into proximate cause opens up a Pandora's box.
So I want to take one step back, Your Honor, because they're not alleging that my clients engaged in any illegal retail sale. None of my clients actually sell to consumers.
No, the complaint says they aided and abetted. Justice Thomas asks you what violation? I believe the violation they claim is that the dealers are selling to straw buyers.
Sure. And I just wanted to be clear that I think that the chain of causation, I think it's relevant both to proximate cause and aiding and abetting.
I know that gun manufacturers themselves, they can only, because of the laws here in the United States, they sell through licensed dealers. They have to ship it to an FFL, which FFL is Federal Firearms License. They're required to ship it to the FFL. What the FFL does with it, the manufacturer has no way to control.
Yeah. If they're licensed already.
Yeah.
I think that the chain of causation under the statute doesn't start at the illegal sale because we aren't alleged to have engaged in an illegal sale. It starts with the conduct that they allege constitutes aiding and abetting the illegal sale, which is the way that we manufacture and distribute our firearms. But I also think that's relevant to aiding and abetting liability because we're not alleged to have aided and abetted any cartels or any illegal purchaser. We're alleged, in this case, at least as they presented it here, to have aided and abetted the retailers. And so they have to carry the argument that somehow we're liable for every illegal retail sale in America because we know that some small percentage of retailers may sell the firearms illegally and don't do more. Now I dispute
Mr.
that.
Francisco.
Yeah, okay. Exactly. That's like, I mean, I could come up with a ton of others like it, but the point is, how the hell are you supposed to know which ones are doing it, not doing it, how many there's no way they could know that. There's just no way. All right, we're going to go into Neil Gorsuch. I got to find him. There he is. Okay. I'm not sure. Does he start talking right away? I think.
I just want to pause there for a second. Sorry to interrupt you, but just to follow up on Justice Sotomayor's question, put aside aiding and abetting. Assume for the moment that you did aid and abet the sales. Your clients aided and abetted the sale of guns to bad apple dealers, ones they knew or intended to even for them to sell on to people in Mexico doing bad things. They knew that. They knew all of that. How would you not have proximate cause in that hypothetical?
So sure, Your Honor, and that is a huge assumption, but even accepting that assumption, for the same reason there was no proximate cause in Hemi Group. even if you assume that we're on the hook for that illegal retail sale, you still have a multitude of independent crimes in between that sale and injury to Mexico. You have the straw purchaser that gives it to the actual purchaser. You have a smuggle across an international border.
I understand, but my hypothetical assumes that you know all that. Your clients know all of that, maybe even intend it. Now, whether there are allegations of this complaint sufficient, put that aside. But if you know or intend all of that, then what?
I still don't think that establishes proximate cause when you have an intervening independent crime. And I'll point you to Hemi Group, Your Honor.
Oh, yeah.
And
Okay, he's mentioned this a couple of times. Hemi Group or Hemi Group?
Hemi.
Hemi
I
Group.
think it's HEMI.
Do you have any idea what he's referring to when
let me
he's
look it
talking about
up.
Hemi Group? I'm assuming it's a prior ruling in a case like this, but let's find out. So we're gonna, while he looks that up, we're going to jump ahead, and the next person to talk is the Supreme Court justice who does not know what a woman is, and that is Ketanji Brown Jackson, and that's going to start at the 1837. And that's going to go to 2306. So we have several minutes of what is a woman, just so you know. Did you find anything yet? It's okay. I'll start the clip. If not, we can come back to it. He's currently deep in research, looking up what the Hemi Group thing this guy keeps referring to is.
January
Do you have
25th, the Supreme Court decided Hemi Group LLC versus City of New York, holding that the City of New York could not state a claim under RICO against an out-of-state cigarette seller based on its failure to comply with the Jenkins Act reporting requirements.
Okay. It's talking about the tax cigarette thing he was talking about earlier. Okay.
January 25th, 2010.
Okay. So a little while back. Yeah. All right. So we're going to jump in here. Justice Jackson, to 1837-ish to 2306. Here we go.
don't cite a single case.
Mr. Francisco, that's sort of what I'm a little confused about, and I wanted to focus on, which is, it seems to me that the core of your argument, both here and in your brief, has been that there's an implausible theory of aiding and abetting liability based on what they've alleged, and no case in American history supports this theory of liability, as if the question before us is evaluating the viability of Mexico's theory. And what I'm looking at is a statute that I think really makes this case about the scope of the predicate exception, that it's not really, an invitation to assess as a common law matter whether or not we think these facts allege aiding and abetting liability. Would you agree with me that the PLICA statute takes off the table theories of tort with respect to these kinds of manufacturers, and really the only question is whether the statutory exception applies in this situation?
Well, I think I would agree that we're arguing about what the meaning of the statute is, but the statute can only be triggered if they find a violation that's the proximate cause. Here, the violation that they've identified.
I understand, but that
aiding and
proximate
abetting.
cause analysis is coming up in the context of an exception to the immunity that Congress has set forth. Is that right?
Sure, yeah.
And I think that's important because the scope of that exception may not be coterminous with our understanding of aiding and abetting liability as a common law principle. In other words, you look at Twitter, for example, and you say, okay, is what is being alleged here the same as aiding and abetting liability as it was set forth in that statute? That was a totally different statutory scheme. That statute, JASTA, in the Twitter case, was about allowing for these kinds of claims. And so what counts for aiding and abetting liability in Twitter may not be what Congress intended for this exception. I feel like we have to focus on where we actually are in this context in making this determination.
Well, Your Honor, I think that's where I might very much disagree with the theory that you're articulating. I think that they do have to show a violation. They've alleged it's aiding and abetting. There's no aiding and abetting in the air. What Twitter purported to do was look at traditional aiding and abetting principles.
I understand, but Twitter was a different kind of statute. We have said that, you know, when we're doing statutory interpretation, when we're thinking about aiding and abetting liability, it may not be the same in every statutory scheme. And I guess what I'm just trying to, I mean, this is not supposed to be like a statement that is necessarily against your position. I'm just trying to understand the framing of this. It seems to me this is a statutory interpretation question about the meaning of what the predicate exception says, knowingly violated a state or federal statute. Aiding and abetting is in the examples. It's not even in the actual core statutory statement of what would qualify. So shouldn't we be focused more on trying to understand what Congress meant when it was accepting, you say narrowly, a certain kind of claim?
Well, Your Honor, to the extent I understand what you're getting at, first, I do think that you really do have to grapple with the aiding and abetting liability issue, and Twitter sets out the framework.
Now, I'm sure he's talking about a case.
Yeah,
Regard when
with
he's
Twitter,
mentioning
yes.
Twitter. I'm not entirely sure what decision he's referring to or process, but it doesn't matter.
Okay.
Because he's talking about the establishment of the aiding and abetting statute. That's what they're arguing. They're arguing aiding and abetting, but they're not showing a causal connection there. They're not showing, well, how are they aiding and abetting? And it seems that Justice Brown's position is, well, they can claim anything they want without any evidence, which doesn't sound right to me. But I guess she's saying they can make the statement, but it's our job to determine if it's factual. Maybe that's what she's saying, but I don't know. What do you think? Does that line up with what you were thinking? Okay, so we got a little bit more.
But even if you want to take a step back and look at what Congress was getting at more broadly, Congress's entire purpose was to prohibit lawsuits just like this one. It was trying to prohibit lawsuits that had been brought by the city of Chicago, the city of Cincinnati, the city of Boston on theories and seeking relief exactly like this one.
Yeah,
so if you adopt my friend's position on the other side, you have essentially gutted PLACA. And remember what the larger purpose of PLACA was. It was actually to ultimately protect Second Amendment rights by preventing plaintiffs from bankrupting the industry through frivolous lawsuits. After all, the Second Amendment doesn't really mean anything if there's nobody from whom you can buy a firearm.
That's it exactly. That is an absolutely glorious wrap up with a bow. Here you go statement. The Second Amendment doesn't mean much if you're not able to acquire the means to protect yourself. So, yeah. Okay, so we're going to go right into Gorsuch. And we got about 3 minutes, 23:07 to 25:57.
I'm willing to
Francisco, just to follow up on this, PLACA, as you call it, says that you've got to show a violation of a state or federal statute. And Justice Thomas asked you, and I'm still not sure we've completely identified what that statute is. I think it's 18 U.S.C. 922, maybe 923. You agree with that?
Your Honor,
we don't know.
I don't think the complaint was clear on it. We did speculate about that. We speculated about it in our brief. I think that might be the statute.
And then trading and abetting would be 18 U.S.C. Section 2, I think.
I think that's right, yeah.
Okay. All right. I just want to be clear on what is being alleged. And then your friends on the other side make a good point about our precedent in direct sales, which I did not write either and is about 80 years old, too. I want to give you an opportunity to respond to that.
Sure. I will agree with them on one point, that direct sales is their single best case, and direct sales isn't even close. In direct sales, you had a manufacturer that was selling to a specific doctor in such massive quantities that there was no possible lawful explanation. And in addition, the manufacturer then further encouraged that doctor to buy more by offering it massive discounts on bulk purchases. So to use the language of Twitter, you had both a very high degree of scienter and a very high degree of conduct and encouragement.
Well,
nothing like that here.
That raises another question I had, and then I'll stop. But in terms of aiding and abetting under Section 2 for 922, if that's what we're talking about, those are criminal statutes. And Rosemond says that aiding and abetting in the criminal arena generally requires intent, not knowledge. But you didn't make anything of that.
Well, Your Honor, I think that
that's he makes a phenomenal point, which is aiding and abetting requires willful behavior, requires foreknowledge that you're helping a criminal. If you don't know they're a criminal, you can't be held responsible for aiding them because you're just helping a regular person. And now that he Gorsuch mentions it, it is interesting that he didn't present that as any kind of argument. It is odd.
Because they don't come anywhere close on any standard, whether you call it knowledge, whether you call it intent. Remember, in Rosemond, the defendant was actually part of the drug transaction. The question was, did Rosemond, in participating in that drug transaction, also know that one of his collaborators was going to shoot somebody? You don't have anything like that here. The other respect in which this is far different from Twitter, in a way that also highlights direct sales, is that in Twitter, the defendants there were far more active. We were here just a few weeks ago talking about algorithms. The way that algorithms work is that they match up the creator's content with the user's interests. So it starts out with ISIS's vile content. It surveys the billions of users on the platform, figures out which ones are actually interested in that content, and puts the two together. We're not doing anything even like that. This is an a fortiori case after Twitter.
Okay, now I get the connection to Twitter. They're talking about like these violent videos where obviously crimes are being committed, and like the connection there and all of that. And he does raise a good point, which is the algorithms kind of fuel that to a degree. I'm not entirely sure what they ended up deciding on that case, but I see now like what he's talking about as far as Twitter goes.
Counsel, the complaint says that 2% of the guns manufactured in the United States find their way into Mexico. And I know you...
2%.
Yeah.
Which is a very, very tiny fraction of...
It's John Roberts now
the
speaking.
Amount of guns that are sold. I mean, holy cow. All right, so we're going to go right into Chief Justice Roberts, and we're going to get him 2558 to 2802. So about 2 minutes.
Dispute that. But is there a number where your legal analysis might have to be altered? If it's 10%, if it's 20%, at some point, the proximate cause lines that you draw really can't bear the weight of the ultimate result.
So, Your Honor, I take their complaint as it comes. If we're talking about proximate cause, I don't think that the percentage would actually matter when you have a multitude of intervening independent crimes. In Hemi, for example, I don't think it would matter whether the city was losing, whether everybody was not paying their taxes in New York City or just a small percentage were not paying their taxes in New York City. What mattered is that you had the independent decision of the New York City taxpayers not to pay their taxes that broke that chain. Here you have a multitude of intervening independent crimes. So I don't think that percentage would matter at all on my.
Well, I mean, at some point it must matter. I mean, I understand you don't want your theory about the different steps, but if it ends up that most of your product or whatever number you want to get to a change in your view ends up there, you've got to know that. And if you know that, do you still have to go through the intricate step by step, or can you just say, this is what they make and pick whatever number you want? 70% of it ends up in Mexico.
I still think you do have to go through that analysis, Your Honor, but even if you disagree with me, I'm willing to accept the allegations in their complaint and the number of 2% and to be quite confident that that is not enough for proximate cause, particularly when their theory is that simply because a firearm was found in Mexico at a crime scene and can ultimately be traced back to a particular retailer that sold it in the first instance, that means that the retailer illegally sold it and that we knew the retailer illegally sold it. Even the ATF and the federal government rejects that theory.
Thank you. Justice Thomas?
Yeah.
How are you supposed to know?
Right. There is no possible way that you can predict that unless you're willfully selling to criminals. In which case, if the manufacturer is willfully selling to cartel criminals, okay, maybe there's a case there.
Yeah.
But that's not what's happening here. Okay. So we're going to go into Justice Thomas, and we got 2 minutes of him, 2803 to 3003. So here we go.
Mr. Francisco, in direct sales,
He got such a deep voice. I like his voice, man. I really do.
there was exactly that, a direct sale to a doctor. And the seller worked closely with the doctor to work around the limitations. In your brief, you summarized the chain that you've mentioned or alluded to a number of times. Mm-hmm. Would you just list the chain for our benefit?
Sure. Starts out with a licensed manufacturer, a manufacturer that the federal government says is allowed to make firearms. It then distributes its legal firearms to licensed distributors who the federal government says are allowed to distribute them. They then sell to licensed retailers that the federal government says are allowed to retail. Those retailers, some very small percentage of them, unknown number, but some small percentage of them, transfer those firearms illegally to straw purchasers. Straw purchaser then hands it over to the actual purchaser. You then have a smuggle across an international border, yet another violation of law. The smuggler then presumably gives it to the cartels who are illegally possessing the firearm in Mexico under Mexican law, as my friends have described it. Then the Mexican cartels engage in murder and mayhem against the good people of Mexico, all of which in turn causes the Mexican government to have to spend money to respond to that murder and mayhem. With respect, there's not a single case in history that comes close to that. They don't even cite cases that find a manufacturer, I think, ever liable for the unlawful criminal misuse of its products, other than the cases that PLACA was meant to prohibit, and perhaps other than the Avis case, the Florida Supreme Court case. But they certainly don't cite anything that comes close to that chain of causation, which is more extreme than the cases that PLACA was meant to prohibit.
Justice Alito?
Okay. We're going to jump ahead to 3640. And this is back to what is a woman? Let's see. 36.
Back to Jackson.
40. Yep. Ketanji Jackson. All right. And we're going to go 3640 to 4028 on this. Let's see here. All right.
Justice Jackson?
So, Mr. Francisco, I'm just trying to understand what you mean by resolve it on aiding and abetting liability. Don't we have to have a conception of aiding and abetting liability that is specific to this statute? You seem to be drawing on others, and I thought we took a statute by statute approach to aiding and abetting liability. We've held as much. We've said that before.
Well, Your Honor, in Twitter, you were applying aiding and abetting principles that arose in the context of a murder when you were talking about social media platforms. I think the whole point of Twitter was that there is a set of general aiding and abetting principles, and that is the law that informs what aiding and abetting.
I
don't even know how you would do this kind of statute-specific aiding and abetting liability outside of the general principles.
Well, I thought we were only looking at aiding and abetting to the extent that Congress mentions that in an example in the statute. So what we're really doing is trying to understand what Congress intended with respect to the exception that it put in this statute. And so to the extent that it references aiding and abetting liability in one of the examples, that is just to illuminate the meaning of the statutory terms that exist there, right? I mean, it's sort of odd to me that suddenly a common law of aiding and abetting liability is coming in to in your view, be dispositive of how we think about this case?
Sure. Well, I think that it's an example that the reference to aiding and abetting in the statute is an example of a violation that then triggers the statutory exception and the proximate cause analysis. So you have to understand that.
That's a whole lot of legalese. So I don't think, like, they're just basically going round and round about the aiding and abetting statute and whether or not there's a conceptual, I guess, medium or constant, right, regarding what aiding and abetting is, or if in this case, it sounds like Jackson is advocating for, well, in every other thing we ever do, it's a statute by statute thing. Okay, maybe, and this is just me, but aiding and abetting is it's a settled science. It like they have clearly laid out what aiding and abetting is and means, right?
Yeah.
I mean, I don't think there's much confusion on what it is unless that's what she's struggling with, which, I mean,
what it means to aid and abet a particular crime. Again,
As Congress intended it for the purpose of this statute.
Well, and I think it's not that plausible to say that Congress had some completely idiosyncratic view of what aiding and abetting was for the statute, as opposed to just looking to the principles like this court looked to in Twitter, which are just the basic aiding and abetting.
Can I just ask you about your proximate, can I ask you about the proximate cause? Because I'm still a little confused about where you start your proximate cause analysis. I listened as you discussed with Justice Thomas the series of steps from your clients to the alleged ultimate harm. But it seemed to me that the first moment of illegality in the chain, that, as you articulated it, was the retailers selling to the straw purchasers. Am I right about that? You say your clients do things that are legal. They sell to other legal buyers and et cetera, until we get to that straw purchaser point, right?
That is the first moment of illegality, but I don't think that's the sole step relevant to a general proximate cause analysis.
Right, but we don't have a general proximate cause analysis. We have a statute, and the statute makes clear that we're starting with an action in which a manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to the sale or marketing of the product. So it seems to me that the first step, given this statute, is the moment of violation, of illegality, as opposed to some theoretical original point.
And my answer to that question is no, but it doesn't matter. No,
I understand you think you make it anyway, but I'm just trying to understand why you're insisting that it's way back here.
Because what the statute says is there has to be a proximate cause between the defendant's violation. Our violation is not the illegal sale itself. We don't sell to consumers.
But you say you don't violate at the beginning, so I don't know what your violation is unless it's the point of illegality.
I think that's his entire point, is we're not violating anything. It's not us that's violating anything. So how then could you come after us when we are not violating anything? I think, is she driving to this point, or is this just over her?
I think it's going over. We'll see.
Yeah.
Aiding and abetting. That is the whole aiding and abetting theory.
Thank you.
Hold on.
Thank you,
Let's take it back a little bit.
Violate at the beginning, so I don't know what your violation is unless it's the point of illegality.
It's the aiding and abetting. That is the whole aiding and abetting theory.
Thank you.
The whole aiding and abetting theory. In other words, they say we're doing this. The whole point of this is they believe this, but that's not what's happening.
Thank you, counsel.
Thank you, Your Honor.
Okay. We're going to go into our first appearance by basically Mexico's lawyer. This person is called Catherine Stetson, and she works for a company called Hogan Lovells or Hogan Lovells.
You might want to make it smaller just on the screen.
Oh, yeah.
Covering.
Thank you. Hang on. There we go. Thank you. It's a global law firm that represents many well-known clients in a variety of industries, including corporate, finance, technology, and healthcare. They've worked for Dell, Papa John's, Starbucks, Walmart, all kinds of places, as you can see. Now, I'm going to show you guys something really briefly, and a lot of things are going to make sense once you kind of have a grasp. So about us, we can go through all this, but it's the same. It's the standard lawyer speak. We're good at what we do. We win our cases. If you look at the top of the screen, this is Hogan Lovells is the website, the company, the law firm that this individual works for. And our thinking is Trump administration executive order tracker. That's what pops up. So you're like, okay, that's an interesting thing to have right there. But it all becomes clear when you click on it. And it says, let's see here. Where is it? Our team is ready to help identify and navigate this surge of executive actions and provide the legislative, regulatory, and legal advocacy necessary to support clients in responding effectively to these developments as they go through the implementation process. In other words, we are more than happy to sue Donald Trump and his administration on your behalf as long as you pay our bills. So, let us get back to this. All right. So, so Catherine Stetson is who we're going to hear from. Again, she is the lawyer, basically the lawyer from Mexico. And that's going to go to 4245. Here we go.
Ms. Stetson?
Mr. Chief Justice, and may it please the court. Mexico's complaint pleads that petitioners aided and abetted violations of specific federal gun laws, and that those violations proximately caused Mexico's harm. That satisfies PLACA's predicate exception. First, the complaint details that petitioners deliberately supply the illegal Mexican market by selling guns through the small number of dealers that they know sell a large number of crime guns and who repeatedly sell in bulk to the cartel traffickers. Petitioners' arguments ignore these allegations. Next, as the court said in Twitter, an aider and abetter is liable for harms that were a foreseeable risk of that violation. That framing, foreseeable risk, is the proximate cause question. As this court put it in Bank of America, does the harm alleged have a sufficiently close connection to the conduct the statute prohibits? The answer is yes. The laws broken here are designed to keep guns out of criminals' hands. Those violations put guns in criminals' hands, and those criminals harmed Mexico. Petitioners' arguments would rewrite PLACA and proximate cause law far beyond this case. Petitioners argue that independent criminal acts sever the causal chain. But an independent act, criminal or not, only breaks the causal chain if it is not foreseeable. These acts were foreseeable.
They were not.
That's right. Okay. So let's talk about foreseeable, right? Just briefly. It's critical to understanding what they're trying to argue. So they say that just selling guns, period, it's foreseeable that could end up in, the hands of someone who shouldn't have them. Well, I mean, I suppose technically, but so do you just not sell any guns because some could possibly end up in the hands of someone who shouldn't have one? That's the stupidest thing I've ever heard.
That's her argument.
Yeah. And they're specifically selling to these dealers who specifically sell to the cartel. Okay. I somehow doubt that Smith and Wesson, or whatever brand they're guided against that Smith and Wesson owns, I highly doubt that they're looking specifically for someone who's going to break the law in other countries. I mean, maybe they are, maybe, but it just seems a little weird to me.
Petitioners argue that Mexico's injury is not direct, but their directness argument borrows from cases involving indirect victims.
And more importantly, and I've waited long enough to say this, stop trying to clean up your problems by suing companies in the United States. Get rid of your own friggin' cartels. Guys, like, come on. This is bullshit at this point. I'm pissed because, like, we are seeing people dying from the fentanyl and the gangs that are crossing the friggin' borders, and Mexico is seriously going to sue our gun manufacturers for their criminals? Really? That's some stupid ass shit, man. I'm just going to say that.
I'm just waiting for Trump to declare the cartels to be terrorist organizations, and then
he already did several.
Okay, so he could send troops down there
to
take them out now.
Yeah. CD and let's see. We'll get the specifics later, but yes, Trump did designate several cartel groups as terrorist organizations.
So it's just a matter of time before he takes them out.
And Mexico authorized special forces use. So it's like you said, it's just a matter of time. And Mexico's already rounding some up and delivering them to the U.S. Did you see that?
I think I saw that.
Yeah. So there's stuff in the works. Trump's not going to put up with this bullshit. No. Which good. I'm tired of watching our people die for preventable stuff. All these drugs coming across the border, all these illegals coming across the border, it's all preventable. All of it.
Mexico is not an indirect victim. We are here at the beginning of this case. This court need not vouch for Mexico's allegations, but it must assume they are true. And the issue at this stage is not whether every...
Is that accurate?
I don't know. I was kind of surprised at that statement.
Yeah. I don't know that that's accurate.
No. That you don't have to necessarily believe, or how did she put it?
That you have to basically assume everything in the brief is true.
Uh-huh.
But what if it's not? Like, what if they blatantly, abjectly lying and they can look at it and go, yeah, this is bullshit. I know this for a fact is bullshit. What do? You like, that seems like I don't know, dude. I'm sketchy about that. I don't think that's right. I'm not an attorney. We've made that very clear. This is just a layman who worked in the correctional system. I've been involved with the criminal justice system, but I'm not a trained attorney, and I don't pretend to be. I don't even play one on TV. So, yeah, but that don't sound right. That does not pass the sniff test.
Every aspect of Mexico's complaint survives, but but it must assume they are true. And the issue at this stage is not whether every aspect of Mexico's complaint survives, but whether any of it clears the predicate exception.
So basically, we're throwing everything at the wall, and if a tiny little piece of toilet paper sticks, then we're right. They're wrong. Give us a bunch of money. It doesn't work that way.
Wouldn't you like to see the Supreme Court justice's face when they said that?
Dude, you have no idea how bad I wish we had video in SCOTUS, man. I get it, right? I get it. But yeah, I would. You guys see that, like, Clarence Thomas, he's a very expressive man. His face says a lot. I would love to be like watching him, man.
Especially with that statement.
Yeah, what the?
Mexico should be given a chance to prove its case. I welcome the court's questions.
Yeah, okay. Of course you're going to say that. You're their attorney. You got to give us a chance to prove our case.
That's why you're here. And like, when you start off with a bunch of bullshit, then I don't know that you deserve to be heard, but that's not how it works, I guess. All right. Speaking of,
Clarence Thomas, that's who's up next.
Yep.
How is your suit different from the types of suits that prompted the passage of PLACA?
That's a good question.
Our suit is different, Justice Thomas, because the types of suits that prompted the passage of PLACA specifically did not allege that the manufacturers had violated any law. So if you look, for example, at the Third Circuit's decision in City of Philadelphia, the Illinois Supreme Court's decision of City of Chicago, each of them specifically made the point that those manufacturers were not alleged to have violated any federal or state statute. They were being held liable for actions solely caused by criminals. And that's the important balance that this.
What fucking balance? Cartel members are criminals. How is this hard?
By solely caused by criminals. And that's the important balance that this bipartisan act struck. If an action was solely caused by criminals, manufacturers of guns, like any other product, wouldn't be held liable. But
Well, it seems as though the only connection or the difference would be the allegation or the assertion that you have an aiding and abetting problem with respect to the manufacturer. You could have done that in the other cases, couldn't you?
Which is exactly what the other lawyer was saying. We think the only thing that even possibly can be discussed here is aiding and abetting, which they can't prove, and which there's no way to prove because blah, 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 blah. I mean,
can't read people's minds.
Right.
I don't know that they could have, and they certainly didn't. And PLACA, for more to the point, could have also barred, as many states did, all lawsuits against manufacturers. Many states barred lawsuits by cities. Many states barred lawsuits by all manufacturers.
All Mexico is doing is trying what Chicago already tried, New York, which is where PLACA came from. They talked about this. These cities tried to sue gun manufacturers, saying it's their fault that our crime is horrible. It's their fault that all these criminals are hurting people. It's the gun manufacturer's fault, which is stupid as shit. And the court agreed. They said, yeah, no, this is not going to fly. Congress got together, made laws, made stuff to make sure that that didn't happen anymore. So now that it can't happen in Chicago or Boston or New York, now they want these, by the way, the same people that were up trying to defend themselves about why they spent millions and hundreds of millions and billions sometimes on illegal immigrants. Just saying, same cities. But yeah, PLACA is already a done deal.
PLACA didn't. And what PLACA did, many states barred lawsuits by all manufacturers. PLACA didn't. And what PLACA did was to preserve exactly these types of claims. You asked a question about the specific allegations of illegality. I want to direct you to paragraph 249 of the complaint.
Paragraph 249 of the complaint. Paragraph, not word. Holy crap, dude. Think about like how much that is. And you got to read all of that. You got to translate it from legalese to.
There is a list at paragraph 249 that includes 18 USC 922, several different subparts, A6, D1, 923 G1, 924A1A, and those map closely onto the predicate exception we're talking about, including, of course, that first example of the predicate exception, which involves aiding and abetting a straw purchase, which is at the core of what we are talking about. That's
right. But how are you supposed to be aware that I think she's alleging that they're seeking these buyers out. Basically, they're specifically picking criminal gun sellers. I don't know, man. That sounds like a hell of a proof of burden of proof. A hell of a burden of proof there.
18 U.S.C. 922A6, 922T1, 922M, 924A1A, 923G1A. Each of those are specified in the complaint, and the manufacturers and distributor in this case are alleged to have aided and abetted all of them.
Counsel, I'm sorry.
Just one last, have any of these violations been violations that ATF has pinpointed?
They have
That's a really good question.
not been
That ATF has pinpointed?
They have not been violations that ATF has pinpointed, and that's a point that the petitioners are fond of making. I think the issue with ATF, as the complaint alleges, is that ATF, and you can find this at paragraphs 126, 129, 133, ATF, just because of its resources, is only able to look, even every year, at about anywhere between 3 and 10% of licensed dealers and manufacturers and distributors. And if PLACA, again, had wanted ATF to be the sole arbiter of this, it could have barred cases altogether. It could have required a conviction. It could have required the stripping of a license before any of these allegations were allowed to go forward. It didn't do any of those things in the predicate exception.
Counsel.
Okay. So they chose either not to contact the ATF to put them on the trail, or they did and the ATF found nothing. All right. We go right into
Roberts, right?
Roberts, correct. Chief Justice Roberts. And that's from 4611 to 4844. Just a couple, 2.5 minutes. Here we go.
So in his argument this morning and also in his brief, Mr. Francisco focused on two particular cases, the Twitter case, of course, and you engaged with that in your brief, but also Hemi Group, and you cite that once in a string cite at page 42 of your brief. I wanted to give you an opportunity to say a little bit more about that.
Certainly. So Hemi Group, of course, is pertains to the proximate cause issue. And Hemi Group, I think, is in a line with all of the cases that talk about what my friend Mr. Francisco calls direct harm. And that's something that you heard a lot in his argument. Direct came up a lot. Independent came up 13 times. Direct harm, if you look at Hemi Group, if you look at Associated General Contractors, Holmes, ANZA, Bridge, there is a list of proximate cause cases. And if you look at each of them, what you will find is that the issue there was that the victim who was bringing the complaint was an indirect victim. So this court, like many of us, finds it hard to speak with one voice on proximate cause. One of the few times it has is in Lexmark. And what Lexmark says is the reason for that directness requirement is that there ordinarily is a discontinuity between the injury to the direct victim and the injury to the indirect victim, so that the latter is not surely attributable to the former. That, I think, is an important component of the proximate cause argument. And I want to touch on this independent idea because it came up so much. As I said in the opening, an act that is independent can still be foreseeable. It's when an independent act is unforeseeable that you have the intervening cause that breaks the causal chain. So Mr. Francisco mentioned that 1876 case that Justice Gorsuch did not write about Milwaukee Railroad. That is the case that says the primary cause may be the proximate cause of a disaster, though it may operate through successive instruments as an article at the end of a chain may be moved by a force applied to the other end. So it's not a question about one step or a causal chain. It's a question about whether something breaks that chain. Hemi was an example of something breaking the chain because you had unlawful contact over here and an injury over there, and the two weren't connected by anything other than a very articulate series of steps. The injury and the conduct were very different.
Okay. I see now like where she's going with it. I'll say this. It's really her only option as far as trying to find firm footing for them to sue. Because let's face it, guys, that's the point of the lawyer who's working for the Mexican government, is to find some sort of crack in the already existing legislation to allow them to sue gun manufacturers. That's the whole point of this. So she's picking at every little thing she possibly can. It'll be interesting. We got a few more clips for you, but we're getting long in the tooth. Not too much more. It's interesting. It's certainly interesting. Our next clip is Sotomayor. Right? Yeah. 48-45 to 52-44. Here we go.
It's nearly impossible to say that something's not foreseeable
Right.
in a chain. It doesn't help me when people talk foreseeability. I'm much more helped by the restatement third of torts that basically says you impose liability for harms within the scope of the risks that made the defendant's conduct wrongful in the first place. That makes much more sense because, as I started earlier with Mr. Francisco, we know that a straw seller is going to sell to someone who is going to use the gun illegally. Because if they weren't, they wouldn't use the straw purchaser.
Right. Yeah, I mean, they wouldn't be a straw purchaser if they weren't. Yeah.
Fair point.
And that illegal conduct is going to cause harm.
Right.
And harm like this, that the gun is going to be used in some way to injure people. Correct?
That's correct.
And that basically is much easier than saying that all foreseeable harms are, you're responsible for all foreseeable harms. You're only responsible for those that your wrongful conduct causes a risk about.
That's
Right. But what is considered wrongful conduct? I think that's the crux of this. If you're just a manufacturer that sells to people who can legally buy from you,
Yeah, how are you supposed to know
yeah,
how they're going to do
you
it?
don't know what the hell they're going to do. And like he said, there are several steps from the manufacturer to the eventual criminal that they have nothing to do with. Mexico's argument is you shouldn't even sell guns at all because some criminal might use it.
Yeah, that's their argument.
Guys, like, bruh.
That's exactly right, Justice Sotomayor, and that's why I started with that reference to Twitter, because when Twitter
Yeah, they found a kindred soul there. Yeah, you're right. She latched onto that. You heard that? Oh, thank you for throwing me the lifeline.
Yeah.
talks about the aider and abetter being responsible for harms that are a foreseeable risk of the conduct, that's the closest thing that I've seen that comes to encapsulating what a proximate cause test is. It's foreseeable
Now, can I
risk.
go back to what's troubling me? You have the manufacturers aiding and abetting, in your theory, by producing guns that are singularly attractive to the cartel because they're designed in a particular way that cartel members like because they're showy. They're making erasable serial numbers, which obviously are attractive to criminals because every criminal would like to erase the serial number if they can. So that's what you claim is aiding and abetting. But what are you claiming Interstate, the distributor wholesaler, did? Other than selling the product, they don't design it. They didn't do any of the, they didn't design it. They didn't have anything to do with that. They just have a product they're selling. So how do we make, how are your allegations enough with respect to Interstate? And if we were to say they're not enough with respect to Interstate, doesn't that break the causal connection with
Speed
the
it up a little
manufacturer?
bit.
There we go. Okay. Apparently, it took my computer a moment to catch up. I tried to pause it, and for some reason, it sped it up. That was weird.
Manufacturers, that break the causal connection with the manufacturers.
Justice Sotomayor, the complaint actually details 6 or 7 different examples of how the manufacturers are actively participating in the illegal market.
I'm
One of them
accepting
is
that.
design. Yes, yes.
I'm asking, tell me what it says that the distributors are doing.
What it says the distributors are doing, including the one that's named in this complaint, are knowingly supplying the dealers who we know sell unlawfully across the
But
board.
knowledge is not enough. We have repeatedly said, mere knowledge is not enough. You have to aid and abet in some way. You have to intend and take affirmative action to encourage what they're, not to encourage, but to participate in what they're doing.
What this court said in Rosemond is a person who actively participates in a criminal scheme, knowing its intent and character, intends that scheme's commission. That's the criminal aiding and abetting standard.
Yeah,
Hold on.
Is a person who actively participates in a criminal scheme, knowing its intent and character.
Knowing its intent and character, which means you have to prove that. And how are you going to prove that a firearm manufacturer is specifically violating the law in order to make its way to particular dealers, particular wholesalers that sell to particular dealers that sell to particular customers? That's an awful lot of probable cause, or beyond a reasonable doubt, right? That's an awful lot of beyond a reasonable doubt.
How I think it's probably going to be 9-0.
I see. Yeah. I was worried there for a minute, but I think they're getting around to it now. All right. Couple more seconds.
Intends that scheme. Participates in a criminal scheme, knowing its intent and character, intends that scheme's commission. That's the criminal aiding and abetting standard.
yeah,
That's it. Okay. Someone we have not actually heard from yet, and that is Alito. We're going to go 5713.
To the point you were just discussing.
Okay.
Are there any allegations in the complaint that the petitioners knowingly sell to specific red flag dealers?
Yes. If you look at paragraph 247, and I'll read it because I think this one is important. Defendants supply dealers with all the guns they can pay for, without any public safety conditions, even if a gun dealer has been repeatedly found to have violated gun laws, been indicted, its employees have had federal gun licenses revoked, or has repeatedly supplied cartels in suspicious and obvious sales to traffickers, including repeated bulk sales. That is an allegation that goes directly to specific rogue dealers. And that gets us, I think, to the Twitter direct sales dichotomy. What Mr. Francisco says is that Twitter was very actively managing something. Twitter was actively managing, to the extent it was managing anything at all, its algorithm. And what this court said in Twitter was that kind of starting the platform, sending it out into the world, and standing back and watching, which was the phrase in Twitter, is not enough. What you need is active, culpable participation. The active, culpable participation here is continuing to sell guns to rogue dealers that you know are the problem dealers. That is exactly.
How do you know that though? The one thing that she said that I picked up on is they are purposefully selling to this dealer, that dealer, this dealer, that dealer, who maybe had a violation or who had multiple or who had an employee lose their license. I didn't hear any specifically selling to a retailer who had had their FFL license revoked. Now that is criminal behavior, but I'm not hearing that. I'm hearing, well, this place, had some concerns, but I didn't hear lost their license. They said maybe an associate working there did, but the business itself, I didn't hear that. I I mean, I don't know what the predicate cause stuff equals, but it sounds like that would be pretty important. All right, so we're going into, oh God, Amy Coney Barrett. What a disappointment. All right, 5833 to 10100.
The dealers, Justice Alito was asking you about specific red flag dealers, but that paragraph doesn't identify dealers, and it seems to me that that's one of the distinctions between this case and direct sales, and for that matter, this case in Twitter. Let's talk about Twitter. There was a specific rogue actor, ISIS, and there was a specific attack in France. And so the attempt was to draw the line between them, and we said it wasn't enough. In direct sales, there was a specific manufacturer, pharmaceutical company selling to a specific doctor, causing specific harm. And Justice Alito asked you what specific red flag dealers there are. You haven't sued any of the retailers that were the most proximate cause of the.
Wow. Oh, I didn't know that. So they haven't filed against the people that are allegedly committing the actual crimes.
Harm. You haven't sued any of the retailers that were the most proximate cause of the harm. You haven't identified them that I can tell in the complaint.
Wow.
Justice Barrett, there are many, many paragraphs that specifically identify rogue dealers in the complaint. If you look at approximately paragraphs 147 to 203, they identify specific dealers that have been found to have sold guns in bulk to traffickers that go across the border. If the question is, you haven't named in paragraph 247, which says that these manufacturers know that they're selling to dealers who sell to cartels, I think that is pushing a little bit past what is necessary for drawing reasonable inferences from a motion to dismiss. But I want to pause to.
Wait. Hold on, because I want to make sure I heard this right. Hold on.
Paragraph 247, which says that these manufacturers know that they're selling to dealers who sell to cartels, I think that is pushing a little bit past what is necessary for drawing reasonable inferences from a motion to dismiss. But I want to.
I want to make sure I'm not misinterpreting this. Is she saying that us saying they did it is enough? Probable cause?
What I think she's trying to say.
That can't possibly be what she means.
I don't know.
Who knows? They try anything. I think right now she's trying to keep it alive and not dismissed. I think, because I think it's an interesting choice to go straight for don't dismiss it because we met the minimum. That's what it sounds like, is like a no, please. Like a cat grabbing your leg when you're trying to go, leave the house.
Pause to on Twitter and direct sales. Direct a motion to dismiss, but I want to pause to on Twitter and direct sales. Direct sales involved an entity that was selling large quantities of morphine to a doctor. The entity was licensed, the doctor was licensed. And if you look at direct sales, what direct sales says is that the quantities that were at issue were in line with that defendant's marketing practices. There was nothing unusual about the quantities at issue there. What was unusual in that case, and what is different in that case, is that the direct sales manufacturer did not know that that specific doctor was a problem. It had been put on notice that there were other doctors who were selling lots of their products to people who shouldn't be getting them. But unlike this case, where these manufacturers and the distributor are alleged to know who the dealers are and what problems they are causing, the manufacturer that was held liable for criminal conspiracy in direct sales didn't know anything about that doctor. All it knew was that the doctor kept sending them legal order forms and they kept fulfilling the orders. That was direct sales. This case is much like direct sales, if not stronger, for that reason.
No. I would wholeheartedly argue.
I don't think that's a relevant.
Well, here's the thing, right? So one, we're talking about narcotic medication, right?
That's not.
It's heavily regulated by the government. There are very specific rules that have to be in place, but that has nothing to do
No.
with firearms, and somewhat like I think is grasping at straws here. But okay, our next clip is Kavanaugh, and we got what 2.5 minutes. Brett Kavanaugh 10101, 10101 to 10332. Here we go.
What do you do with the suggestion on the other side and in the amicus briefs that your theory of aiding and abetting liability would have destructive effects on the American economy, in the sense that, as you've read in the briefs, lots of sellers and manufacturers of ordinary products know that they're going to be misused by some subset of people. They know that to a certainty. That it's going to be pharmaceuticals, cars, what you can name, lots of products. So that's a real concern, I think, for me, about accepting your theory of aiding and abetting liability.
You know what? That's actually a really, really good point, because like he said, there is a certainty, certain products that are legal, right? Here's a perfect example. Have you guys heard of Galaxy Gas, Whippets? It's the thing they put in like whipped cream, the little nitrous oxide that like gives it air, makes whipped cream fluffy. You know, the little whipped cream things, the ones that you screw on, like that they have at nice restaurants, the metal one, right? Yeah. And you screw the little capsule on. You ever watch Hell's Kitchen? Okay. Well, anyway, they got these little like CO2 cartridges, like for air pellets, right? But it's a different mixture. Anyway, that puts the air in the whipped cream so it can fluff up. But I guess some people have been using it incorrectly. There are cars that show up at mechanics with a whole passenger side full of used whatever, Galaxy Gas, Whippets, they got a bunch of names, right? You know damn good and well, if you're manufacturing this stuff, that there are people who abuse it. I mean, they added like dyes and bitter aid. You know, they put that bitter stuff, I guess, in various sprays because of that reason. Like, they know, they're well aware. The point is, Kavanaugh says, so if we open this door to this, it could potentially destroy the U.S. economy. And I think that's something that like really needs to be understood. The sheer like potential here for harm to regular American citizens that don't care one way or another about the Second Amendment or firearms. Maybe even like, you know, would like them all banned if they could. Well,
And relatedly, you've referred often to the motion to dismiss, of course, as you're well aware. Getting past that is often the whole thing. So I don't think we can just rely on the motion to dismiss. But the broader point, would be interested in your reactions, how we rule for you, but don't cause that problem that is identified with great force in the briefs.
Sure. So let's take Budweiser as an example. As you heard Mr. Francisco say today, if Budweiser had was alleged to have a practice of selling bulk quantities of Bud Light to liquor stores that were arranged next to high schools, and it was selling more and more into those high schools, knowing that those liquor stores were regularly serving underage students. And in fact, the Bud Light designed to put out a new can that says "Best Prom Ever" and sold it right into that high school. That is the allegations in this case. If you have a product manufacturer of a dangerous product that is alleged to have done all of the things knowing who they're selling to and what is being done with that product, then and only then, I think that product manufacturer has a problem. If you look at the examples that are given in PLACA that aren't at issue in this case.
No, what's up?
Never mind.
Okay. One of the interesting things about her argument is she's saying they're designing these things specifically to appeal to the customer base, AKA cartel. right? Where they're specifically designing stuff attractive to cartel members. Well, if that's the case, right? So what? Because there are people who like cartel stuff who are not criminals. There are plenty of people who there, for example, right? There's this like chrome plated AK at Rural King, right? Or gold plated or something. Anyway, very gaudy, right? Or no, it's a I don't know. I don't know what it is. I saw it, I remember it, but I couldn't tell you now for sure what it was. I know it was shiny and plated and was obviously designed to radiate bling, right? There are plenty of people who would buy that, who are not criminals, who are not cartel members. Do they have good taste? It's not up to me to determine. That's up to them. Taste is just like beauty is in the eye of the beholder, right? I find that a very, very shaky argument.
Very shady.
The examples that the congressmen and senators were concerned about in Placa were when a car dealer sells a car to someone who later drives drunk, when Campbell's is sued because someone is killed with a soup can. Those are the things that Placa was concerned about. This case marches through in detail allegations taken as true at this stage that these
taken as true at this stage. How many times are you going to say we're full of shit? No, seriously, that's like the third time that she's been like, you got to assume everything we say is true. You know, it's assumed true. It's assumed true. How many times are you going to say, yeah, we're full of shit, but we can't tell you that yet? I mean, maybe I'm looking at it wrong. Maybe before you dismiss, you have to assume that everything is true. Maybe that's what she's saying. I have no idea. I have no idea. Again, I'm not a lawyer. I only play one on TV. So, no, I don't. But I could. Never know. You don't know my life.
Know that they are selling a dangerous product to specific rogue dealers who are selling to straw purchasers for the cartels across the country.
What if a beer?
Oh, okay. We're going to jump right into Alito. We only have two more clips, Alito and one more. If I can find him, there it is. All right, so we're gonna go 103.33 to 104.41, so slightly over a minute, and then we end.
Jackson.
What?
We end with Jackson.
Why would you do that to me? No, just kidding. Here we go.
I'm sorry, I cut off your sentence. Did you? What if a beer manufacturer knows that the per capita beer sales in a small college town are, 50 times more than another town without a college there? Is that enough?
I don't think that alone would be enough. I mean, you do have allegations in this complaint that the number of dealers that have arranged themselves along the border of Texas and Arizona of Mexico are vast. I don't think that itself would be enough. It would be, the dealers are there, what they're selling, who the bad apple dealers are, because we're not talking about every dealer in the country. We are talking about a small percentage of retailers responsible for about 90% of the crime guns that are found. Those retailers in that college town, if you plug in that hypothetical of Budweiser, and Budweiser was marketing in with some kind of, best first year homecoming ever, then you would again have the problem. But you'd have to have each of those specific allegations in the complaint that you have here.
But again, they're not going after these retailers. They're not going after even the distributors. They're going after the manufacturers who are several steps removed. I think this is going to be a hard one to get past dismissal, honestly. But we'll see. Last clip is
Jackson. But it was our opening one too.
Yeah. So, you know what? We're gonna just let it play, and it goes to 1:10:32. So we got about 5 minutes, a little over, and then we'll be done. So hang in there. Almost done. We'll talk about it briefly, and then we'll let you guys go.
I guess what I'm concerned about, you talked in response to Justice Kavanaugh about what PLACA was about, what it was getting at, and I really thought, as the statute itself says, that it partially, at least, is about Congress protecting its own prerogative to be the one to regulate this industry. That there were concerns, and the statute itself says that, we're worried that tort suits are an attempt to use the judicial branch to circumvent the legislative branch of government. And to me, when you think about that as being the reason why Congress wanted to have immunity in this area, and I'm starting from I'm sure, consensus view that we're trying to do what the statute wants. I think when you think about that, the predicate exception makes perfect sense to the extent that there's a violation of a state or federal statute at issue. Because Congress says we want to be the ones to regulate, but in this particular situation in which a tort suit aligns with a clear violation of the law, then we don't worry that we have judges and the common law system dictating what people can do. I worry that without that clarity, in a complaint like yours, where we don't really see exactly how the manufacturers are violating a particular state or federal law.
Yeah, you heard that right.
Yeah, this is Jackson.
This is Ketanji Jackson saying, I don't see where they're breaking the law. You have not provided any evidence that they are actually breaking the law.
That we're running up against the very concerns that motivated this statute to begin with.
Yeah.
So can you speak to that?
Sure. Justice Jackson, I think if you look at the paragraphs, let's call it 203 to 250 of the complaint, which pertain exactly to the violations of federal law that we started with, all of the specific statutory violations, 922 subparts, 923, 924. What you will find is that there are plentiful allegations that these manufacturers, by knowingly selling to the rogue dealers that they know are selling to straw purchasers, are aiding and abetting that violation. Part of the problem,
I understand, but I guess my point is that Congress didn't want like general aiding and abetting concerns to be what is imposing duties on these manufacturers. I mean, if you look at your lawsuit and what you're asking for changes to the firearm industry safety practices. You say not, putting these kinds of constraints is a thing that should be give rise to liability. The distribution practices, the marketing, all of the things that you ask for in this lawsuit would amount to different kinds of regulatory constraints that I'm thinking Congress didn't want the courts to be the ones to impose.
So let me answer
So that is interesting. It seems that the goal here is not necessarily, at least not only, to punish Smith & Wesson and whomever else is part of this lawsuit. It's to fundamentally change the firearms industry. It's to make it more difficult for you and I to arm ourselves is exactly what it comes down to. And why would any of us be surprised at this point? I'm not surprised.
And abetting liability point first, and then I want to answer your remedies point because I think that's particularly important. Aiding and abetting, of course, was specifically contemplated in PLACA in the first predicate exception itself. Any case in which the manufacturer or seller knowingly made a false entry, et cetera, or aided, abetted, or conspired with any person in making any false or fictitious statement. Aiding and abetting is baked into this.
So you don't read that to be very, very closely tied to the record-keeping violation, the particular statutory violation that's also mentioned.
No, I mean that the predicate exception begins by talking about the action in which the manufacturer knowingly violated, and the violation was a proximate cause, including the exceptions that are mentioned. So aiding and abetting these violations of federal and state statutes pertaining to guns is exactly what this exception was built to do. That is why it was carved out in this bipartisan legislation. But on your remedies question, One of the difficulties, I think, for all of us is that we're here so early. This is a complaint that has asked for a number of different remedies, including a number of different types of injunctive relief. And one of the things that you heard the petitioners and a lot of their amici in their briefs complain about is what these remedies might do. That is for the district judge on remand to make sure that the judge equitably crafts a remedy that is designed to limit the harm to Mexico. Mexico is not trying to legislate gun use in the United States.
Yeah, I understand that. I guess I'm just wondering whether the PLCA statute itself is telling us that we don't want the courts to be the ones to be crafting remedies that amount to regulation on this industry. That was really the point of the entire thing. And so to the extent that we're now reading an exception to allow the very thing that the statute seems to preclude, I'm concerned about that.
Justice Jackson, if PLCA had wanted to preclude any lawsuit against a manufacturer, including for instances where the manufacturer had committed a wrong, it could have done that, as so many different states, in fact, did. What PLCA did in this effort, which, as I mentioned, was joined by members of both parties, was to carefully carve out circumstances where the
Traders.
manufacturer, the seller, was alleged to have done something wrong. The thing they
Shall not be infringed. I don't know how many times we have to say, stop making gun laws. They don't do anything but make criminals out of law-abiding citizens.
joined by members of both parties was to carefully carve out circumstances where the manufacturer, the seller, was alleged to have done something wrong. The thing they were concerned about was lawful design and manufacture and sale of product and injury solely caused by others. That is replete throughout the purpose section of PLCA. PLCA could have been designed quite differently. It was designed this way for a reason, so that harmful actions by manufacturers and sellers breaking the law could continue to be remedied. That was exactly the point.
No, I agree. That was assuredly the point, was so that those actually violating the law could still be punished. And I agree with that. That if you're breaking the law, well, there's recourse there. But what I heard consistently is you haven't given any evidence. You've made a bunch of claims that these manufacturers are doing this with this person, and they have knowledge that this is leading to illegal gun purchases. But they're not providing any evidence whatsoever, according to justices, not me. I'm going to tell you, I have not read the hundreds and hundreds of paragraphs of this case. Not at all. If you guys know someone who did that and you want to go check that out, by all means, be my guest. No. That's too much for me. I'm more than happy to cover it on the channel and talk about like what we learned doing this, but I'm not doing that. That's a lot. So all I can do is rely on the things the justices themselves have said. Liberal and conservative justices have stated, I see no evidence in here. Well, you have to assume the claims are true. Not without evidence.
No.
I mean, or unless they do, I don't know how it'd be interesting to find out. Well, I'd be interested to see how this goes. I will say this. I think that kind of goes against everything that we've been taught as far as the Supreme Court goes, because there wouldn't be a push to take something to the Supreme Court unless that push / claim was assumed to be factual. I mean, you're not going to assume they're lying. You assume, but it doesn't stop them from dismissing them all the time.
Yeah.
I mean, there's constantly so let me ask you this on this case, because I don't know. Did this originate in a lower court and get kicked up?
Yes.
Okay. Where did they start this at? Do you know? Was this like let
me see if I can.
Yeah. See what you can find out. It sounds to me like maybe it was an appeal. Now, because of the way that,
Said the First Circuit.
okay, the First Circuit Court, what, kicked it up to the Supreme Court, or they ruled and there was an appeal, or what does it say on that? Usually I have a bit more background, but we were running late today and we didn't get some stuff done. So yeah, I'm a little bit of a slacker today. No, I was very busy. I'm actually trying, while he's looking for that, I'm trying to bring you guys some educational content. I attended a radio class today and I recorded it, and I'm going to try to do some editing, clean it up. The audio is, the camera is kind of off to the side, but I'm going to try to get it put together and see what I can do with this, because moving forward, there's a number of these classes that are free and they're held, and not everyone can get to the class, right? Not everyone can make it to Cabela's or Bass Pro Shops or wherever that they're being held. Some people are restricted to their home or whatever. So I'd like to be able to provide the information contained in this class for you guys. Did you get anything, Shawn?
I did.
All right. What you want to give us the quick rundown?
From Ballotpedia.
Okay.
The Mexican government sued several U.S. gun manufacturers in federal court, alleging their practices facilitated illegal gun trafficking to Mexican drug cartels, causing harm to Mexico. The defendants moved to dismiss, arguing the lawsuit was barred by the Protection of Lawful Commerce and Arms Act, which they've mentioned many times, the PLACA.
Yep.
Which prohibits certain lawsuits against gun manufacturers.
All right.
The district court dismissed the case, holding that the PLACA applied and barred Mexico's claims. Mexico appealed. The U.S. Court of Appeals for the First Circuit reversed it, holding that while PLACA does apply to lawsuits by foreign governments for harm suffered abroad, Mexico's lawsuit falls within the statute predicate exception for claims allegedly knowing violations of laws applying to gun sales. The court found Mexico adequately alleged that the defendants aided and abetted illegal gun trafficking in violation of U.S. laws, and this proximately caused harm to Mexico. The court rejected the defendants' argument that the casual chain was too attained, finding Mexico plausibly alleged direct harm from having to combat well-armed cartels. The court remained the case for further proceedings, allowing Mexico's lawsuit to move forward.
Okay. All right. Thank you.
So yeah, the First Circuit.
Mm-hmm.
So the Supreme Court had to.
Yeah, they have to hear it because the circuit reversed it. So that's why. Okay, that actually makes sense. It was so initially it was dismissed. They appealed. Mexico did. First Circuit reversed the dismissal. So Smith and Wesson's lawyers appealed. So that's why they're now the plaintiff or respond. No, what's the petitioner? That's why they're the petitioner now. That makes sense. All right. Yeah. Shawn linked the article. You guys can find it. It's on Ballotpedia, which tells you the basic rundowns on the case. It's gonna be interesting. Shawn's predicting a full sweep, huh?
Yeah.
9-0, really. We'll find out.
8-1. I don't know how Cajun's gonna go.
Yeah, I'll say I think it's gonna get squashed. I think it's gonna get dismissed, but I have no idea how these liberals are
Jackson
gonna vote.
Didn't sound impressed.
That's one thing I will agree with you on. I was actually surprised because I thought she would eat that anti-gun stuff up and just, well, yeah, whatever you say, girl boss. But she didn't. Yeah. So I was like, okay.
And Sotomayor was not convinced either.
Right. Which is interesting. We all need to pay attention, I guess, is the short version. Pay attention to our elected officials. Pay attention all the way from federal, all the way down to local, county, city, whatever. Pay attention, guys. I know I'm gonna do the best that I can to start giving you guys the information that I feel is really important. Unfortunately, I've got a lot going on outside the show right now, but within the next month or so, I'm expecting things to greatly calm down, and then I can actually devote time and get this stuff done for you guys. I'm sure that the people who enjoy the show have noticed the drop off in the number of videos recently. I promise I'll fill you guys all in as soon as I can, but I can't yet. I'll explain why later. All right. So without further ado, ladies and gentlemen, I'm not sure. When did you say?
Wednesday.
Wednesday. So
We'll do the mayors.
Yeah. So Wednesday, guys, 7 p.m., we're going to do the hearing with the liberal mayors, the sanctuary city mayors. And oh my God, like there are some truly stunning moments in this hearing. You guys are going to want to see this. So remember Wednesday at 7 Central. Until then, God bless you. God bless Indiana, and God bless the United States of America. I hope you have a wonderful evening. Good night.